Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspective of educational administrators and policymakers. This is episode 49. In this episode, I'll introduce a recent case about the First Amendment rights of community members at the school board public comment sessions, Boddy v. Grech, decided by the United States Court of Appeals for the Sixth Circuit on June 10, 2026. At its core, this case asks whether a school board president can cut off a community member's microphone because she was criticizing the board, and whether a hostile crowd in the room can legally justify silencing a speaker. Here is the background of the case. This case took place at a school board meeting in Xenia, Ohio, a mid-sized school district in Dayton area. It was October 14, 2024. A newly elected school board member named Jeremy Cox has been calling for an audit of the school's curriculum, specifically whether the school district has been teaching concepts associated with critical race theory. The district's superintendent, Gabriel Lofton, has pushed back very hard. Just 5 days earlier, the superintendent emailed the entire community declaring, to be entirely clear, critical race theory is not being taught now and has not been taught in the past. The letter explained Cox's persistence, the school's efforts to quell the inquiry, and that the issue would be placed on the agenda for the October 14th school board meeting. That letter made the situation a community flashpoint, and the October 14th school board meeting was placed on the agenda to address it directly. The auditorium filled with people on both sides. Some came to support board member Cox, others came to support the superintendent. The board president presiding all of this was Mary Grech. When it came time for public comment, Darbi Boddy walked to the microphone. She was not a Xenia resident. She was a former Board of Education member from a neighboring district, a community organizer, and she has come to speak in support of Cox's proposed audit. She spoke calmly and read from prepared remarks. This is important. The court emphasized it repeatedly. She was not shouting. She was reading from a piece of paper. Here is what she said. My name is Darbi Boddy, and I live in Westchester. I'm a previous Board of Education member for the Lakota School District. I'm on the board of Protect Ohio Children and represent the southern part of Ohio and the organization responsible for the heat map. I'm also a leader for Moms for America in Butler County. I recently heard about a failing Xenia Board of Education and the cowardice superintendent who cannot perform adequately in his role. 28 seconds into that speech, board president Grech interrupted Boddy, shouting, "Excuse me." Boddy, however, kept reading. Grech again yelled, "Ma'am, excuse me, I'll cut your mic." Boddy did not stop. She continued in the same calm, deliberate manner, reading her prepared remarks, criticizing the board and the superintendent for a lack of transparency and for, in her view, pushing divisive curriculum onto students. At that point, some audience members began booing Boddy. The boo lasted about 15 seconds. Then, about 1 minute and 20 seconds into her speech, the school board president Grech moved to recess the entire meeting. Another board member seconded the motion, and then Grech walked to the podium and physically took the microphone out of Boddy's hand while Boddy was still speaking. Boddy continued speaking without the microphone as the board walks out of the room. Now here is another critical detail. At the same meeting, another community member named Amber spoke in support of the superintendent. Grech admonished Amber for not addressing the full board, but Amber was never silenced. Amber was never cut off. Only Darbi Boddy, the one with critical views of the superintendent and the board, and Boddy had her microphone taken away. Boddy sued under 42 U.S. Code Section 9083, the Federal Civil Rights Statute, claiming the board and Grech violated her First Amendment rights. She also filed a motion for preliminary injunction, an emergency court order to stop the board from silencing her at future school board meetings. The federal district court denied that injunction. The district court said that the facts were too close to call, that Grech might have mixed motives, and that it was not convinced Boddy would win on the merits. Boddy appealed to the Sixth Circuit Court of Appeals. The legal questions before the Sixth Circuit were this: was Boddy's speech protected by the First Amendment? Did the school board president Grech silence her because of the viewpoint she expressed? And did Grech commit a Heckler's veto, that is, using the crowd's hostile reaction as an excuse to silence a speaker the government disagrees with? The Sixth Circuit reversed the district court completely and ordered the preliminary injunction issued in Boddy's favor. Let me walk you through exactly why. Step 1. The forum. The court began by identifying what kind of space a school board meeting is under the law. The answer is that the school board meeting is a limited public forum. This is a legal category that matters. A limited public forum is a space the government has voluntarily opened for public expression on certain topics. In a limited public forum, the government can impose reasonable restrictions on speech, such as time limits, topic relevance, and decorum rules. But the government cannot engage in viewpoint discrimination. The government cannot allow some people to speak based on whether the government likes or dislikes the message they are delivering. Step 2. Was the speech protected? The district court had classified some of Boddy's language, particularly calling the superintendent a cowardice superintendent, as an ad hominem attack that was not protected by the First Amendment. The Sixth Circuit rejected this analysis. The court said it has never held that an ad hominem attack is categorically unprotected speech, and the Supreme Court has never said so either. So fundamentally, the court found that Boddy's speech was not an ad hominem attack at all. An ad hominem attack is a personal attack directed at an individual's character rather than the substance of that individual's actions, decisions, or arguments. Boddy's remarks did not fit that definition because she was criticizing the board and the superintendent for their policy decisions and performance as public officials. Boddy was not attacking their private character or personal attributes. Boddy did not single out board members by name, or even her use of the word cowardice was directed at the superintendent's conduct in his official role. As the court explained, Boddy's comments concerned the actions of public officials and therefore fell within the tradition of protected political criticism. The court cited a fundamental principle: freedom to criticize public officials and expose their wrongdoing is at the core of First Amendment values. Calling a school board failing or calling a superintendent's performance cowardice is constitutional protected political criticism. The court also emphasized that even speech that offends, angers, or upsets listeners remains protected by the First Amendment. The court explained that the government may not suppress speech just because it is viewed as insulting or disparaging. Quoting the Supreme Court's decision in Mattel v. Tam, the court stated that given offense, it's a viewpoint. The court further observed that the government may not censor speech merely because it's offensive to some, and warned that allowing officials to silence offensive speech would permit a majority to silence dissenters and enable the government to ban the expression of unpopular views. Applying those principles, the court concluded that the body's characterization of the school board as failing and her description of the superintendent's conduct as cowardice were constitutionally protected political criticism. Because criticism of public officials and their policy decisions lies at the core of the First Amendment protection, the board could not terminate the body's remarks simply because the audience members or school officials found them objectionable or offensive. Step 3 was this viewpoint discrimination. Grech claimed she cut off Boddy because of her tone, because Boddy was directing speech at the superintendent personally rather than the board, and because Boddy was starting down the path of calling names. The court systematically dismantled each justification on tone, The veto evidence confirmed Boddy was calm and professional. On personal direction, a prior Sixth Circuit case had already held that a policy banning personal directed speech is facially unconstitutional. On name-calling, the court had previously condemned this exact rationale as impermissible viewpoint discrimination. And then there is the comparison with Amber. Amber was allowed to speak. Darbi Boddy was not. The only variable was the viewpoint. As the court stated, the board may not exclude speech merely because it criticizes the school officials. Grech had no legitimate reason to silence Boddy. The evidence showed she did it because of the viewpoint Boddy was expressing. Step 4, the heckler's veto. The court also addressed Boddy's second theory that Grech committed a heckler's veto. This doctrine holds that the government cannot silence a speaker simply because audience members react negatively to the speaker's message. To explain the doctrine, the court relied heavily on Bible Believers v. Wayne County, 2015. In the Bible Believers case, a group of anti-Muslim evangelists attended the Arab International Festival in Dearborn, Michigan, where they displayed anti-Islamic signs and used a megaphone to deliver provocative messages. Their speech angered some festival attendees, who responded by throwing bottles and other garbage at the Bible Believers. Rather than controlling the hostile crowd, police officers directed their attention toward the speaker and asked the evangelists to stop using their megaphone to amplify their controversial speech. The Sixth Circuit held that the police officers effectuated a heckler's veto by cutting off the Bible Believers' protected speech in response to a hostile crowd's reaction. When a peaceful speaker engages in protected speech and is confronted by a hostile crowd, the state may not silence the speaker as an expedient alternative to contain or snuff out the lawless behavior of the rioting individuals. Nor can the government sit idly by as the crowd imposes a tyrannical majoritarian rule. It should take any appropriate action to maintain law and order that does not destroy the right to free speech by indefinitely silencing the speaker. The same principle applied to Boddy's case. The First Amendment does not permit a heckler's veto. Boddy was speaking calmly. Some audience members, not her, began booing. Rather than quieting the crowd, the school board president threatened to cut Boddy's microphone. The court noted that Grech herself acknowledged that her threat may have helped round up the audience. Instead of using her authority to restore order, Grech took the microphone away from Boddy. As the presiding officer of a school board meeting, Grech had even greater authority to control the proceedings than the police officers in the Bible Believers case. She could have directed the crowd to remain quiet, warned disruptive audience members, or otherwise maintained order. But she chose instead to silence the speaker. The Sixth Circuit therefore concluded that Boddy was likely to succeed on her heckler's veto claim because the school board responded to audience hostility by suppressing protected speech rather than addressing the conduct of the audience. Now let's talk about what this case actually means for you, the superintendent, the school principal, the board members, the board president on a practical day-to-day level. Lesson 1. Your public comment session is a constitutional space. Every time you open the floor for public comment at the board meeting, you've created a limited public forum that carries legal obligations, not just procedural ones. In that limited public forum, you can regulate the time, place, and manner of the speech. You can require speakers to stay on relevant topics. You can enforce a 5-minute or 3-minute limit. What you cannot do is to enforce those rules differently depending on whether you agree with what someone is saying. Lesson 2. Criticism of you personally is protected speech. This is important because it's counterintuitive. If someone stands at your public comment microphone and calls you a failing superintendent, a cowardly administrator, or a school board that is letting students down, that speech is constitutionally protected. You are a public official. Your decisions are subject to public scrutiny. Strong, harsh, even offensive criticism of how you are doing your job is exactly the kind of speech the First Amendment was designed to protect. The person criticizing you does not have to be polite. They don't have to be respectful. What they do have to do is non-threatening, non-obscene, and the same as every other speaker you allow at that microphone. Lesson 3. The heckler's veto is your responsibility to prevent, not to use. Someone is speaking at your board meeting and the audience starts reacting negatively. People are heckling, booing, and disrupting. What do? You do not silence the speaker. You manage the crowd. The court said the government must take any appropriate action to maintain law and order that does not destroy the right to free speech by indefinitely silencing the speaker. You can ask for order. You can warn disruptive audience members. You can threaten to remove those who are themselves violating the decorum. What you cannot do is to treat the crowd's hostility to the speaker as the reason to cut off the speaker. And lesson 4, the comparison to other speakers is the evidence that will define you. In this case, the most damaging factor for the board was the comparison between Boddy and Amber. Grech mildly admonished Amber, who supported the superintendent, but Grech physically removed Boddy's microphone. Amber was allowed to speak, but Boddy was not. When you run a public comment session, your actions are on video. Your decisions about who gets to warn, who gets cut off, who gets their time extended, and who does not, all of that creates a record. Courts will compare how you treat speakers with different viewpoints. If the pattern shows that speakers who criticize you were silenced faster, warned more harshly, or had their time cut shorter than speakers who praised you, that is viewpoint discrimination, and it will not survive constitutional scrutiny. The principles I shared here apply well beyond the school board's public comment sessions. Anytime you are presiding over a forum where the public or staff have the right to speak, for example, a community meeting about curriculum, a staff grievance hearing, a parent advisory council, the same principles apply. You can regulate how people speak, but you cannot regulate what they say based on whether you agree with it or not. And if the room becomes hostile to a speaker, your job is to manage the room, not silence the speaker. Look at the last 3 public comment sessions of your school board meetings. When speakers were interrupted, warned, or cut off, who were they and what were they saying? If you cannot honestly answer that, every speaker was treated identically regardless of viewpoint, your school district may have a First Amendment problem worth addressing before a court does it for you.